And Judge, the last case on my calendar for today that I have is Anthony Deus.
We are on the record in 2023 TR 2777, State of Kansas versus Anthony Deus. Devin Canfield for the state, the defendant in person, and with counsel Darren Patterson.
Your Honor, if I may.
Well, I'm not finding his file. It must not have caught up with the quick turnaround. So go ahead.
Your Honor, I did talk with Mr. Deus. I would tell the court that the sum of the conversation, or I guess the end of it, is that he is asking to represent himself. I would, in review of case law, Judge State v. Collins 257 Can 408, would suggest that he does have the right to represent himself and not have counsel appointed if it's at any stage besides trial. And we're certainly not at trial yet, so that because of that, he does have that right. I think he wants to invoke that right and represent himself, Your Honor.
Mr. Patterson, he did make that clear to me at the last hearing, but he didn't seem to have all of the law in his proper grasp as the court saw it. And so I wanted counsel to be available to him in the event that he wanted to avail himself to it.
I can report we did have a very long conversation concerning the law, and I can tell the court there was just a difference of opinion about it. But okay, that's as much as I can tell.
I object. For the record, I am not representing myself, and I did not accept your forced appointment of Mr. Patterson onto myself. I am not representing myself. I am in propria persona as age of majority, handling my legal affairs as I need to, which is, again, as Mr. Patterson said, retain and attain my rights, and I shall not be abrogated from them. And I recuse Mr. Patterson from being a public defender for me. And I also want to show for the record that...
Wow. Right from the start, this defendant is diving straight into sovereign citizen nonsense. Notice how he refuses to say he's representing himself. Instead, he uses phrases like in propria persona or agent of majority. That's classic sovereign citizen jargon. But here's the problem: no matter what magic words you say, the court still sees you as the defendant. And rejecting your court-appointed lawyer doesn't make the charges go away, it just makes you responsible for your own defense, which almost always ends badly.
Deus, you're charged, as you may recall, with operating a motor vehicle without a valid license in Butler County, Kansas on August 17 of 2023. You were also charged in count 2 with operating a motor vehicle without registration or with expired tags on that same date, as well as in count 3, operating a motor vehicle without proof of liability insurance on August 17th of 2023. So again, that's no driver's license, no tag or registration, and no insurance.
I object before we move forward.
And under Kansas law, if you're going to operate a motor vehicle on Kansas roadways or federal highways or county highways, you are agreeing to follow the law that you will have a driver's license, have a licensed tagged car, and that you will have insurance on that car. Now, if you do not want to have counsel, I'll have Mr. Patterson, I'll ask that he be standby. At this time, you want to represent yourself. You say you don't want to represent yourself, but you can't have it always, you have to either have counsel or represent yourself. So you don't want Mr. Patterson, is that, or other counsel, is that correct?
Hold on, I object. This needs to be addressed first. Can Mr. Regier please show himself on the record in person for this matter?
Mr. Patterson, humor the defendant, or Mr. Regier, why don't you, for the humor of the defendant, show your picture, turn your screen on. I assume you're the one that charged the document. There you go. That's Jared Regier, the prosecutor that filed the case. He's not the witness in the case. The witness will testify at trial. So again, you don't want an attorney to represent you. Is that right, Mr. DeBoos?
I do not want
Okay,
an
thank
attorney.
you.
This part is wild. The defendant is demanding that the prosecutor show himself like some kind of witness. He doesn't understand the basic difference between a prosecutor and a testifying witness. The judge actually humors him for a second, asking the prosecutor to turn on his camera. But you can hear the judge's patience wearing thin. This is exactly how sovereign citizen tactics waste everyone's time in court.
Mr. Jared Regier, you are the one that filed that affidavit, correct?
Your Honor, I'm looking at the information in this case. It does appear to include my name in the opening paragraph of the information.
All right, and I've already told you the nature of the charges. I've explained those to you both at the last hearing and this one. No driver's license is a B misdemeanor. If convicted, you could get 6 months in jail and a $1,000 fine. No tag is an unclassified misdemeanor. If convicted, you could get a $2,500 fine, or you could get a sentence 30 days to 6 months. And the no insurance as a B misdemeanor, it has a minimum fine of $300 up to $1,000, and it has a possible sentence up to 6 months. The next thing I need to know is, do you want a trial in this case?
Object. I need the affidavit to be produced so that way I may see as evidence the sworn affidavit from the individual filing the complaint.
All right, sir, it is your responsibility to either have your attorney file that motion for discovery to get that, or you must do it yourself if you refuse to have an attorney. So that is your responsibility to file a motion for discovery, and the state will provide that to you. Do you want a trial, sir?
I verbally motion right now for the affidavit to be produced on the record of the sworn affidavit to be produced on the record for the verified complaint.
Well, there are rules of procedure, and if you want to review the statutes, if you're going to represent yourself, I would suggest you do so, because those rules of procedure will tell you how to get that. Now,
Here we see the defendant insisting on a sworn affidavit and trying to make a verbal motion right in the middle of the hearing. The judge explains clearly, there are procedures, there are statutes, and if you represent yourself, you're held to the same standards as a licensed attorney. This is key. Courts don't give you special treatment just because you don't know the law. You either follow the rules, or you lose your case.
jurisdiction of the state of Kansas, the District Court, 13th Judicial District. Someone had a comment?
Your Honor, I was just going to say that as Mr. DeBoos has requested to go pro se, he is held to the same standards as a fully licensed attorney. All of this information is available to him through a written request. At this time, I would just ask that we proceed in an orderly fashion and just set it for pretrial.
Hold
Well,
on.
I am certainly Mr. Canfield. I believe I'm proceeding in an orderly fashion.
Can
Now,
I not verbally
I'm going to
motion?
give you one last chance. Read the rules of evidence and follow them, Mr. DeBruce. Now, I'm going to give you one more time. Do you want a trial? And if so, do you want a trial to the court or a trial to a jury?
I want to object to the pro se comment. I am not pro se. I'm in propria persona, and
All
I'm
right.
making that very clear on the record. And if this does go to trial, I retain and claim the Article 3 equity court, and I demand a jury. a trial by jury, grand jury
A
of 12
trial.
jurors.
Well, you're going to get a
This part almost feels like comedy. The defendant is demanding an Article 3 equity court and insisting on 12 jurors like it's a murder trial. But Kansas law is clear: for misdemeanors, you only get 6 jurors. The judge isn't just shutting him down, he's teaching him a reality check. These alternative law theories might sound convincing in YouTube rabbit holes, but they collapse instantly in a real courtroom.
jury trial will be, again, February 7th and 8th at 9 a.m. Now, Mr. Patterson, I'd like you to be available unless you want to, again, take the position that I can't do that, but I would think for jury trial, I could have you on standby. Would you agree or disagree?
Your Honor, I believe the court can order that I be on standby.
All right, thank you, sir. But Mr. DeBoos, if you're going to represent yourself, you've got a lot of law to learn because you're way out there in left field, as the cliche goes, and you're looking at some state matters. You're in district court of the state of Kansas, the 13th Judicial District. And if you're going to represent yourself, there are rules of procedure for this court that you need to familiarize yourself with, rather than those that you're trying to draw upon from who knows what source. So
this is the highlight. The judge straight up tells him, "You're way out there in left field." That's judge speak for, you have no idea what you're talking about.
I object because I need to know the nature of this, whether it is common equity or it is admiralty for the jurisdiction.
I've told you the jurisdiction, sir.
No,
and
you
that's
have
all
not.
we're
I
going to
object
say on
and
that.
show on the record that the
Objection
judge
noted.
has not showed the jurisdiction and the nature of it.
For the final time, this is in the 13th Judicial District, the District Court of Kansas, and this is a traffic proceeding involved.
When defendants rely on fake legal theories instead of addressing the actual charges, they're basically handing the state an easy conviction.